I should have said much more during my introduction. One of the things I wanted to say is that I took advantage of Jan and Helmut's book during the preparation of my article, and they were very generous, together with the authors, to allow me to preview some of the articles, those I asked to review, of their book. So thank you also for this. First of all, I have also now at this point to apologize, because at a certain point I have to leave, but Mirko will replace me. The second session, our second session, we didn't give any thematic focus to this second session, but I know that our colleagues and friends are going to talk about climate change, and if I'm not mistaken, also on warfare and cities, while Helmut Aust will make the general conclusion. Just a few words on the participants. Mirko Sosai is associate professor at the University of Rome, Roma 3. And his interests are wide, I would say. He's great experts of international humanitarian law and law of international organizations, responsibility and accountability of non-state actors for human rights violations. He has an abundant, I would say, scientific production. And he has been also co-rapporteur of the ILA study group on UN sanctions and international law, and is member of the editorial board of the Journal of Conflict and Security Law. While Christine Bakker is today affiliated researcher at the Dirpolis Institute of the Scuola Superiore Sant'Anna in Pisa, and visiting research fellow at the British Institute of International and Comparative Law in London. And she also has a wide production focusing on several topics, especially on international human rights law, including children's rights, international environmental law, and climate change. Helmut Aust does not need any presentation. He's professor at Berlin University. Is the author of several monographs, and he edited also several books on different topics. And we are really very proud to have all these friends and colleagues here, and we hope that this meeting is going to be only the first of several meetings we will organize in the near future. I say that with no further ado, I'll give the floor to Christine, and then I will stay until I can. And then, as I said, Mirko will chair this meeting. So, Christine, the floor is yours.
If this works, yes. Can you hear me well? Very good. Okay, so thank you again, Professor Agnesi. Thank you, Professor Sosai, Mirko, for inviting me to this workshop in the beautiful city of Trento. I'm very happy to contribute to today's discussion by sharing with you some of the main points that I discussed in my contribution to the special issue of the Italian Yearbook of International Law on the topic of cities and international climate law. And in doing so, I will also refer briefly to contributions by others, including in the edited volume that has been presented today, insofar as they relate to the topic of climate change. Now, let me just briefly start with a citation at COP26 in Glasgow. And the mayor of Greater Manchester, Andy Burnham, made a strong statement calling for a more central role of cities and regions in decisions and actions needed to keep the 1.5 degrees temperature goal within reach. Left to its own devices, he said, the market will not get us there. So we will need our governments to have the courage to regulate, but we also need them to have the courage to let go where they can, to hand the baton to cities and regions. And this is a race which can only truly be won from the bottom up. And he concluded with an appeal, I cite again, free up your cities and regions to lead this revolution. Such appeals, and we've already heard today many times, and in the book come up, very, very clearly. Such appeals from cities around the world have become more frequent and more insistent and far more organized in recent years, in particular through these transnational city networks. Against this background, my contribution to the yearbook is entitled, Are Cities Taking Center Stage? The Emerging Role of Urban Communities as Normative Climate Actors. Now, the article and also my brief presentation today will address 3 questions, and I'll try to be very brief. First, does international climate law provide any legal basis for the involvement of cities in global climate governance? Second, what role do cities play in practice, both in the implementation of international climate law, but also in the development or creation of new norms in respect of climate change, of course? And third, what are the potentialities and constraints for cities to become what I call normative global climate actors? Regarding the first question, I think we can be very brief, but let me just briefly recall what are the legal basis for city involvement in global climate governance. Now, it should then, of course, first be recalled that the international normative framework regulating the global response to climate change is composed of both legally binding and non-binding norms. And as you will see, the fact that these non-binding norms, the soft law instruments, are actually increasingly playing an important role here and recognize probably increasingly the role of cities, but rather the soft law instruments than the legally binding ones. Because if we look at the first 2 legally binding instruments of international climate law, the picture is very clear. 1992 UNFCCC, a UN Framework Convention on Climate Change, and the 1997 Kyoto Protocol do not mention cities or local governments at all. It was only in 2010, with the adoption of the Cancun agreements, that local and subnational governments were recognized as governmental stakeholders, which, together with other stakeholders, such as the private sector and civil society, needed to be engaged within the UNFCCC system without, however, specifying what form such engagement would take. It's only 5 years later, with the adoption of the Paris Agreement, 2015, that the active role of local entities was reflected more explicitly, but not in the agreement itself, but rather in the decision regarding the adoption of the Paris Agreement. In particular, and the decision in itself is not legally binding. It's a decision adopted by consensus. So it's interesting that there, one of the perhaps more controversial issues are included in the decision and not in the agreement itself. So that's where we find a reference to cities and other subnational authorities. Indeed, because it says that the Conference of the Parties welcomes the efforts by all non-party stakeholders to address and respond to climate change, including cities, indeed, and other national subnational authorities, and invite them to scale up their efforts and support actions to reduce emissions. But again, the Paris Agreement itself does not make this reference to the duties of cities and other subnational authorities. Although, at least not in that in those terms of giving them any specific obligations or rights. Nevertheless, the Paris Agreement recognizes that climate change adaptation is a global challenge faced by all with local, subnational, and other dimensions. It also recognizes that adaptation should follow a participatory approach that we've discussed already several times, and which obviously comes up very much in this discussion on the role of cities, right? And also the Paris Agreement recognizes that this participatory approach should be based on the best available science and local knowledge systems. So reference, yes, to the local level, but not in according them any specific obligations or roles as such. So it can thus be concluded that international climate law as it stands today does not contain any legally binding obligations for states to actively involve cities in the development or implementation of national climate policies, nor does it impose any obligations or confer any rights to cities. However, indeed, as I said, both the Paris Agreement and several soft law instruments increasingly recognize a certain role for local communities in the global response to climate change as part of a multi-level and cooperative climate action. Okay, but we don't find any guidance, no legally binding obligation there. And indeed, this was also put forward in the book by Anel Duplessis in his chapter of the edited volume, where he also affirms that cities will probably never be deemed as the chief agents in the environmental governance. They are nevertheless central in the global response, as the envisaged climate change law and policy at the global, regional, national and local levels are fast moving closer to each other. And so this recognition of the multi-level governance in climate, in the field of climate change is indeed being recognized, but as I mentioned before, rather in soft law instruments than in the legally binding ones, because also Riccardo Pavoni mentioned before the Sendai framework for disaster reduction, sustainable development goals, but also the new urban agenda. They all have the underlying message very clearly that cities are needed for an effective long-term response, all working into the in the same directions, but without providing any specific obligations or legally binding guidance. So it's in that perspective, indeed, that I've used the term global climate, normative global climate actors. And just to be very brief on that point, I use this term in the sense that beyond the role of cities as normative global, as normative climate actors within the domestic system, based on national law and constitutions, they also increasingly aspire, at least, to play a role as global, normative, global climate actors by indeed claiming a role in international climate negotiations, claiming a role to participate in the law-making process at the international level itself. And this is indeed a question that I've been addressing in the article, and other authors have as well. But also the term global, and I recognize this also in the contribution by others, refers to the fact that cities are challenging, of course, the traditional interstate dynamics of international law, and they're creating new ways of interacting with each other and with multinational institutions by replacing or acting on behalf of their state, not by replacing or acting on behalf of their state, but as independent actors in the global multi-level system. This then leads quickly, briefly, to the second question: what is cities' role in practice in the development and implementation of international law? Firstly, it is evident that cities' role in influencing the development of international climate law has become especially visibly and effective through the transnational city networks. And indeed, as Riccardo also mentioned, several of the city networks have observative status in the climate negotiations to the UNFCCC. So they are present, participate in the discussions, and indirectly, indeed, contribute to international lawmaking. Now, in the article, I've outlined the main, the main objectives and the main features of these transnational city networks, also how they aspire to contribute to the development of international climate law. And they basically pursue three objectives. First, to foster local action against climate change. Secondly, to convince states to recognize and engage and empower the local governments in this debate. And thirdly, to influence the substantive climate commitments and complementarity through innovative climate action. So at these three levels, the city networks are actually claiming their role and trying to indeed contribute directly or indirectly to the norm creation process as well. And Jolien Lin, in her chapter in the edit volume, specifically shows how these networks operate in this global south, and in particular in Asia, where they have a slightly different role, a different composition also. They're beyond cities, also governments, international organizations, NGOs participate in the networks, thereby pooling resources and ideas. And Jolien Lin also specifically confirms that these transnational networks promote the adoption and implementation of indicators, codes of conduct, voluntary certification schemes, etc., and thereby, in effect, making and implementing law, right? Another way in which cities contribute to the implementation of international climate law is, of course, by participating in the design and implementation of national climate plans, as foreseen in the Paris Agreement. The nationally determined contributions are designed at the national level, but increasingly cities are invited to participate in the design of the national climate plans. And indeed, UN agencies are increasingly inviting cities to be part of that process. Another third way in which cities participate or contribute to the development and implementation of international climate law is through two other ways. One, it's through emission trading. We have seen that apart from the emission trading system that we have at the international, at the regional level, and the EU ETS, and at the national level, such as, for example, in Korea or in China, etc., also at the local level, emission trading systems have emerged. And a very important example is the Tokyo emission trading system. And in China, 7 local pilot ETS schemes were launched between 2011 and 2015, which informed the adoption of the Chinese national emission trading system, which was adopted in 2021 and which is now the largest of those schemes worldwide. So there has been a specific role of the local authorities also in fostering these type of very important mechanisms to address climate change. And of course, in that context, also norms are being set. How high can the emissions be, etc. And this is indeed a point which was also highlighted by Jorge Viñuales and Lucy Lou Reimers in their chapter in the book. A final point I wanted to make on the way in which cities can and do influence development of climate law is through climate litigation. And as you've seen, especially since the adoption of the Paris Agreement, a very large number of cases have been brought before national courts, also slowly before regional human rights courts and under international dispute settlement mechanisms. We see a huge development there. And interestingly, in some of these climate cases, cities are also starting to play a role. And this one important example is in France, a case brought by 14 French local authorities and 5 NGOs against the oil company Total. It's called Notre Affaire à tous. It's a case where the plaintiffs has asked the national court to order Total, which is at the origin of around 1% of world's greenhouse gas emissions, to recognize the risks generated by its activities and to improve its policies. And this is based on the French law of due diligence. So there are developments here also in climate litigation. And I will turn to my third question and conclude in view of the time. The third question I address indeed is, as other authors have too, and I think is really at the heart of the discussion of today's workshop, is what are the potentialities and constraints for cities to play a normative, to play a role as normative global climate actors. Now, regarding the potentialities, of course, we see that there are lots of external factors, globalizations, urbanization, decentralizations, which favor the role of cities. But of course, we have several constraints, which are of different types of nature, legal nature, political, factual, institutional, etc. But let me just say a few words on the legal constraints, because this is what many of us have addressed. To conclude, these constraints, of course, concern the basically the way how international law is conceived, the question of legal subjectivity. And indeed, many authors in the two publications we discussed today have addressed the question, is international law as it stands today still adequate to address current challenges on the one hand, but also the current agents and actors as they are indeed asserting themselves today. And this indeed has led to several answers, and the discussion will probably need to be pursued long beyond this, but the two publications clearly seem to have made a very important contribution here. And I just wanted to, in discussion, I can come back if you like about some examples that were given also by Samantha Besson and José Luis Martí on how the representation of cities in international climate negotiations should also be reviewed through a new multiple representation system. As Kotze also has argued, we need perhaps to even develop a new Earth system law. Discussion also evolve around the question, can global environmental law or transnational environmental law, can those theories help us to reconceive a role of cities in international law? Do we need to depart from the state-centered level? And these are indeed all questions that we need to consider, both more generally in terms of how do we need to reform international law to take more account of these agents and the challenges, but also indeed on how the cities themselves can foster a more active role in this process. Thank you very much and look forward to the discussion.
Thank you, Christina. Thank you very much. You were able in summing up the different ways for cities and local communities in participating in climate change negotiations, in the norm creating process at the international level, and also in litigations on these issues. So I think that you really gave a broad picture of how cities matter in international law, which is something different from being subject to international law for me. However, I thank you really very much. And another thing I forgot, of course, but everybody knows it, is that Mirko Sossai is the co-organizer of this meeting. And I thank him very much for what he did together with me. And now I give him the floor. He's going to talk about international law, cities and warfare. So, and this, I can say also this is an anticipation of an article that will appear on the next issue of the Italian Yearbook of International Law as a sort of appendix to the 2020 volume. Mirko, the floor is yours.
Thank you very much, Pepe, not only for your kind introduction, but also for giving me the chance to co-organize this meeting today. That is, I think, a fantastic opportunity of a dialogue between two different collaborative efforts of a book and an edited collection in the Italian yearbook. And I think this is really a chance to learn again a lot with respect to the topic of cities and international law. When Francesco Francioni asked me first to write an article on cities and an international humanitarian law, I accepted, of course. I couldn't do otherwise, I would say, but I was also a little bit worried for two reasons. The first reason is that there is nothing on international humanitarian law in the edited book, and I thought that it was a precise decision of the authors, and they had good reasons, in my view, for doing this, because at first I thought that the issue of cities and international humanitarian law was a little bit different in comparison with other areas of international law, because it's more difficult to find a protagonism of cities in the shaping of international law. Cities could be seen more as an object of regulation or better of protection. But then maybe I'll try to show why I was wrong, and maybe it's important to look at this topic. And the second reason is that there is indeed a consistent literature on the issue of urban warfare and international humanitarian law. And I tell you, the impression I had, it was that indeed is one of the subjects in which expertise and technical expertise is so fundamental that it's not only because I thought to have an impossible task, but because it's really difficult to establish a dialogue between issues concerning urban warfare, international law, and other topic covering the same relationship between cities and international law. But still, I started from precisely the chapters included in the edited volume, looking for references to the issue of wars and violence, and indeed I found something. And maybe this is something that happened that helps our discussion. We couldn't have this morning already the chance to discuss the importance that the chapters on migration, refugee law, and cities have within the context of the research handbook. And indeed, of course, there is an indirect relationship with warfare, but indeed, I think the new protagonism of cities as a city of refuge has to do with very much the issue of people leaving their own countries because of situation of warfare and seeking protection precisely for that reason. And I think that dynamic bottom-up that we already discussed in the field of environmental law is also pretty evident with respect to the way cities try to implement refugee law and human rights law, I would say even against the decision of the central governments, and by finding even innovative solutions to correctly implement refugee law and human rights law, by, for example, finding new ways to allow safe and legal pathways toward, for example, toward Europe, by using the tools of international law to allow asylum seekers to safely arrive in the country of destination without the risks of the route through the Mediterranean Sea of the Balkans. And I think Barbara Omen wrote a fantastic chapter on that. The second reference is contained in the chapter by Alejandro Rodiles on the relationship between city and violence from the viewpoint of counterterrorism. And I was rather surprised that indeed the starting point, one of the starting point of the analysis of Alejandro was indeed that of the relationship between urban warfare and international humanitarian law. And by looking at the big problem of the difficulties sometimes of distinguishes distinguishing situations in which cities are in a situation of peace and or in a situation of war, which is a typical question for international humanitarian lawyers. That is the issue of the threshold for application of international humanitarian law. And this is indeed something that I analyze in the paper that you mentioned, Pepe, that is going to be published in international, in the Italian Yearbook of International Law. Indeed, the legal disciplines with respect to the threshold for application of international humanitarian law is pretty clear, and there is a clear separation between situation of armed conflicts on the one hand and situation of disturbances and tensions or isolated and sporadic acts of violence. But still, there are indeed still nowadays situations in which this level of intensity of violence that we find in situations like, for example, with respect to the drug war in Mexico, that led some authors to conclude that indeed the situation in Mexico amounted to an armed conflict of non-international character, triggering the application of international humanitarian law. But then the question becomes, is really a good thing? Well, we come from a world in which the application of humanitarian law was supported in situation in which it was not clear whether there was or not an armed conflict. But nowadays, because of the evaluation because of the evolution of human rights law, there is an understanding that in some situation, the application of humanitarian law actually could even exacerbate violence. So this is, I think, a relevant topic of discussion from the viewpoint of humanitarian law. So the first image that I want to carry in this discussion that I found in the edited book, and that it's of some interest for our discussion, is the image of the global insecure city, in which there are levels of violence, in which the topic remains that of the legal qualification of that violence. And Latin America is a fantastic case study. There is a second image, and I'm now focusing a little bit more on international humanitarian law. That is let's say, the image that allows us to reflect upon the issue of visibility of cities in the evolution of international humanitarian law, and it's the concept of open towns. And open towns, it's something that belong, of course, to the Italian culture, thanks to neorealism, of course, Roberto Rossellini's Roma città aperta, but it also shows us how it started the protection of cities in international humanitarian law. So undefended localities, open towns, using the, let's say, the old concept, should not be attacked. And only defended towns might constitute legitimate military objectives. And here again, using an historical approach towards the evolution of international humanitarian law, I think it's interesting to look at this evolution from the very concept of undefended localities and open towns that are not to be attacked, to a shift in focus from that concept towards the concept that indeed defended towns can be attacked. It's a shift in focus that tells a lot about what is happening right now in a variety of scenarios. But the fact that defended localities might constitute legitimate military objectives does not follow that cities in toto become military objectives, simply because there are some combatants, for example, resisting enemy forces that are there. And indeed, if we look at Article 51, paragraph 5, letter A of Additional Protocol 1, we see that indeed there is a prohibition for its indiscriminate nature of an attack that treats a single military objective, a number of clearly separated and distinct military objectives located in a city, town, village, or other area containing a similar concentration of civilians or civilian objects. I think this is a significant evolution of international humanitarian law. But then the problem becomes how to apply the principle of distinction in a situation of urban fighting. And the problem indeed is the proximity of military objectives with civilians and civilian objects. Now, the question I try to address, trying to establish a dialogue with you and those dealing with cities and international law, is how cities then is portrayed by international humanitarian law in this context. And what I found, maybe it's not very original, but still I think it allows us to draw some conclusion, is that the city as an object of protection is portrayed as a densely populated area, and therefore the issue is that of the protection of the civilian population as such. But more and more, the emphasis is on the protection of objects indispensable to the survival of the civilian population. And I think this is a significant development, and it's not by chance that one of the major issues of negotiations in recent years has been that of adopting a non-binding declaration, though relevant from a political and legal viewpoint, regarding the use of explosive weapons with wide area effects. And the issue of the impact of explosive weapon of human services on urban context has not only to do with the issue of those killed and injured as civilians, but has to do with the reverberating effects, has to do not only with the immediate effect, but with the future effect. In particular, when these explosive weapons damage essential infrastructure and services like water, electricity, sanitation infrastructure. And I think this is an interesting perspective with respect to another common feature of our discussion that has to do with the relationship between international law, cities, and future. So the attention that is increasing with respect to the future generation and the long-term effects of hostilities. The third picture, and I'm going to conclude, the third image is that of the city under siege. And indeed, since the siege of Sarajevo, and of course, the recent sieges of Aleppo and other cities in Syria, and tragically with the recent siege of several cities in Ukraine, Mariupol among them, of course, the legal analysis very much focused on how to treat sieges, because traditionally what we think is that sieges are not per se legal from the viewpoint of international law, but nowadays, since sieges focus very much on urban spaces, there is an ongoing discussion with respect to whether actually we can individuate a situation of a legal siege. And I cannot elaborate on this point, but the main question then becomes, what are the effects of sieges, in particular with respect to the consequence of the starvation of the civilian population? And indeed, much discussion has been devoted to the correct legal qualification of starvation of the civilian population as a war crime. And here, the problem is indeed with respect to the image of city as the environment in which the the siege occurs, and in particular with respect to how to interpret the concept of purpose with respect to what amounts to starvation of civilians. Now, it's clear, and with that I would like to conclude my presentation, that it makes perfectly sense to discuss the issue of the relationship between cities and the evolution of international humanitarian law within the context of our discussion on cities and international law for a number of reasons. First, undoubtedly, there is as a matter of fact, there is a relationship between the urbanization and the urbanization of warfare, with a lot of implication with respect to the fact that the increase in hostilities in urban area is putting pressure on the interpretation of well-established IHL rules. Second, there is an interest in the representations of cities, less as centers of authority, more in terms of the population that lives there, more in terms of the infrastructure of essential services. And then it is also relevant from another reason, because indeed we cannot exclude more visibility of cities with respect to a more proactive role as for the correct implementation of international humanitarian law. It's not by chance, perhaps, that our editors here in their introductory chapters stress that local governments across the world refer to global norms and practices, be it with respect to macro level questions like nuclear disarmament, which is definitely an issue also of humanitarian law, or to the more immediate questions of preventing terrorism or other form of violence in their cities. In that regard, I see that indeed, if we look at the issue of the prohibition of the use of certain means and methods of warfare, cities and city networks have been absolutely fundamental in supporting the global campaign towards the prohibition of nuclear weapons. I think that the whole idea of the catastrophic humanitarian consequences that will result from any use of atomic weapons very much comes from the experience that cities like Hiroshima and Nagasaki had on the effects of nuclear weapons. So in that respect, I see the importance of cities in being promoter of international law, but I see also the importance of cities in other areas, once again, in supporting and implementing certain rules of international humanitarian law, including those concerning evacuation from cities. And I think that cities played a role with respect to the issue of those that evacuated from the Ukrainian cities and helping them in finding a place of shelter and refuge. So perhaps there are other areas that also need further discussion, but indeed I see that the whole approach on cities and international law and international humanitarian law is actually more multifaceted than I imagined since the very beginning. So thank you very much.
Thank you. Thank you very much, Mirko. And once again, we understand that cities can be the critical conscience, so to say, not only in climate change, migration, environmental issues, but also in maybe in arms reduction, or in more generally, I would say, in the application of international humanitarian law. But I would say that Now the floor is open for further questions, and I'm wondering whether anyone also from those who are attending on the website are interested in putting questions to our colleagues. Then I again. Or if there is no one else, if you want to intervene from the website, you can please participate, ask for the floor on the chat. Maybe there is something, someone. Oh yes, there is a question.
Yes.
Carlo De Stefano. Carlo from Roma 3 is making a long question to Professor Becker. So yes, please. Meanwhile, I will leave the floor.
Okay, thank you. Perhaps to Professor Becker. Some authors, especially Louis Coetzee, which was mentioned earlier this morning by Professor Pavoni, have proposed a new paradigm of Earth system law, which should in theory replace the anthropocentric approach that is prevailing in international environmental law. I ask you whether you see any seeds of this new and somehow revolutionary approach in the initiatives undertaken by cities and related to transnational networks, or conversely, is the role of cities aligned to the classical policies of international environmental law, including sustainable development, and what matters rather is their higher degree of flexibility and possibly effectiveness in tackling international environmental law commitments, including in relation to the ambition cycle under the Paris Agreement. Thank you.
Yes, thank you very much. This is a very interesting, but also very complex question, because indeed the chapter by Coetzee in the edited volume is a very thought-provoking one, and really proposing us to reconceptualize international law based on earth science, and really considering how the ecosystems and natural systems basically influencing life on Earth, on the planet, can be much better. It can be taken as the basis almost as of the formulation of norms, and so this goes very far, and I think in theory it's an extremely interesting concept, and probably indeed we need a revolutionary approach to tackling climate change, and also of adjusting the international legal framework that we have to better encompass indeed these profound impacts on the Earth, and using science more specifically. So I am very much intrigued by these proposals as my first answer. At the same time, I see, of course, the difficulties in practice and how to shape this and how to then apply it. And this leads then to your second question: do I see in the action and in the calls from the transnational city networks any ideas going in that direction? Or else are they more functioning in the traditional paradigms of the Paris Agreement, of the Sustainable Development Goals? As far as I have seen, predominantly it is the second answer. Yes, they predominantly, as far as I've seen, in general, especially the larger networks, C40, but also ICLEI and the Global Compact of Mayors, etc., they basically employ the existing norms and structures that we have and try to influence those, and try to play a role in the existing frameworks of the constituencies at the UNFCCC, etc. Of course, these ideas transpire and are brought into the debate, but it's rather from this traditional angle. And I wonder also, I didn't say in my conclusion, but of course, I mean, the climate crisis is so rapidly increasing and advancing. I think that, of course, we need to continue our reflection on how to revolutionize international law. At the same time, we need to also use the structures that we have, and that is not even happening. We do have structures under international law. We do have possibilities for states to adopt more stringent climate measures, and they are not all exhausted. I think the city networks, indeed, to conclude, are actually calling on that as well, using what we have more effectively. And of course, in the background, the theoretic idea of going more into this Earth system approach will certainly play a role. Thank you.
Thank you very much. We have another question. Yes, no, I don't see other questions. At least if there is any, please let us know, but I don't see anything written. You have in any case the chance to take the floor. Well, yes, of course, please.
So I think, and thank you for your talks. One question that came to mind, and I think it permeates the whole discussion about cities, is whether cities are state actors or non-state actors. And that question has impact on lawmaking, but also, I mean, for your case, international humanitarian law. And one question would be whether a city could possibly be a non-governmental armed group in certain circumstances, with implication that this has, obviously, in terms of what IHL part applies. And of course, that how do you define it as a non-state actor or not may have also implications for jus ad bellum and the question of the right to self-defense against non-state actors. Of course, again, in particular circumstances and particular facts on the ground. And the second question that again relates to how we view cities as non-state actors, that could, and that goes to the previous panel, trying to connect now a bit the discussion with all the panels that I have attended. If we were to see transnational city networks as spaces where law could be created on its own, without the download, without the state creating those rules and then they implementing, the non-state actors are simply implementing. Do you think that there's, and that's a question with my hat as the principal investigator of a grant on state silence, there is a question of whether that particular practice of a non-state actor groups are now opposable to states. So if there is no direct involvement of the state necessarily, but the upload into custom comes because states are silent towards the new standards that are adopted through these networks. And perhaps that silence may mean acquiescence, acceptance of law opinio juris, thus uploading it to customary international. And that has obviously relevance for many different fields of international law. So thank you very much.
Yes. Well, I can definitely start, and leaving maybe to, if you want to add anything to the last part of the comments that we just received. Well, thank you for the question. And indeed, there is a challenge in understanding to what extent cities, or what we define as cities, within the legal categories that we know under international humanitarian law. You made, I think, a very good example with respect to what extent a city or its inhabitants, once organized or having the control of a certain area, could be qualified as an armed group from the viewpoint of the law of non-international armed conflict. But there is another example that came out indeed the first days after the Russia's invasion of Ukraine. To what extent actually the resistance of certain inhabitants actually could be understood in terms of the well-known category of levée en masse that is well known from the very beginning of international humanitarian law, that give emphasis to the element of the spontaneity of the reaction. So indeed, I think that we could develop that. I think it goes beyond perhaps your initial comment with respect to the distinction between state or non-state actor, but to what extent the organization, let's say, of the city in taking arms could be qualified on the basis of the existing legal categories under international humanitarian law. Yeah, I don't know if there is anything that you want to add.
Well,
I have to save my points for the concluding observations.
Yes, Miguel, thank you for your comments. I do find that indeed an intriguing question also to consider to what extent can cities be considered as non-state actors in the climate regime. So far, as far as I said before, there are very little references to the local system, but then they are clearly considered there as governmental actors. So there's no doubt about that. And in that respect, I also wanted to add something I didn't say in the beginning, and of course, please come back to me if I haven't really captured your second comment. I'm happy to go back to that. But an idea with that, something I didn't mention, I think is interesting to, and it's linked here. The transnational city networks have been and are still lobbying very much to, it is also part of the norm creation process, to introduce, beside nationally determined contributions, also locally or regionally determined contributions. And that, of course, would be a recognition, full recognition of these sub-national authorities as state actors, but by indeed adopting in the wider international framework also specific commitments which would in themselves not be legally binding, but if they were to be included in the general international climate regime, they would of course gain a lot in normative value as well.
I understand that Helmut wants to intervene first before the conclusion, so you have the floor.
So just because it doesn't fit my concluding observations, but on Dana's point on the opposability, I was really, I found that very interesting to learn at some point when I asked colleagues at the German Foreign Office to what extent they are actually monitoring what cities and local governments do. And then that was like 10 years ago when I started work in the field, but then this colleague said, well, we can no longer keep track. It's so much practice. Like in the 80s, in the Cold War, we had a much better grasp because there was this phenomenon of local development aid and also twinning, and there we always kept a close look at things and intervened when something was going wrong. But now there's so much practice that we cannot keep track. And I think in Germany this also has a federal relationship as the cities are parts of the Länder. And then I recently learned that in France there's actually legislation which regulates in a much clearer way what local governments can do. And there's much more guidance than from the French Foreign Ministry on what cities can do and which types of agreements they can enter into. So I would presume that if practice arises out of something in which the Foreign Ministry in France has been involved, it would be much harder to deny that this might have some relevance also if standards are emerging. So it might depend also on the context of how local, not just the domestic legal framework is set up, but also how this is organized and in practice within the state. And I think we would also need more research here in this respect.
Thank you very much. Thank you very much. Before, I think, giving the floor for the conclusion to Helmut, I don't see other questions, so I'll take just 1 minute to thank. Oh, you have, of course. Please.
Because I really appreciated your presentation, and you already know because I read the forthcoming article in the Italian yearbook, so I already knew it a little bit, and it was very nice to hear you speaking about that and trying to simplify this very, very multifaceted field of the law. So I'm very happy that in the end you were happy to engage in this research and find out that there is really room to think about and to make reflections. I found, well, there are many points in your presentation. I think I found a couple of them really interesting, particularly interesting. The one is this focus that you say nowadays there is a focus on this a duty to protect the objects indispensable to the civilian, to the protection of the civilian population when it comes to protection of cities under IHL. And I found that particularly interesting because, of course, that's the rule of IHL, which is also used to protect indirectly the environment and to a certain extent also cultural heritage, which is frequently located within cities, which are also part of UNESCO World Heritage, for example. So I think that's also a nice way to reconcile, let's say, the urban and the rural, no? So see, what is indispensable to protect is not only the civilian population, like an anthropocentric view of IHL, but also what is part of a wider community, which also includes the environment and cultural heritage. So there was a short reaction. And then the other topic of the cities under siege, which of course is dramatically timely and increasingly relevant. I followed your points and you're explaining in a very clear way what the stakes are in the area. I was particularly interested in the case of Mariupol, no, and the siege of this famous siege, recent famous siege, also been very discussed in Italian scholarship. There is, I'm pretty sure that you read that this blog post by Luigi Crema discussing the siege of Mariupol, and I think that it's taking the position which is a little bit provoking and in a way thoughtful. He says that there must be a limit placed upon the belligerents to say that a city must defend itself, that a city by all means, no deadlines, like the siege of Mariupol was actually occurring. So in that context, my intriguing reflection would be about whether there is you can see any possibility for a city to criticize their national governments for asking them to defend for a unlimited period of time, and for example, in that case, to be attacked in a very nefarious ways, and for example, completely destroying a city which is full of cultural objects, etc., etc. And of course, that is actually what happened in Mariupol to a certain extent with the destruction of the theater, etc., etc. So how do you see that argument?
Thank you, Riccardo, for your comments. I think it's very difficult to discuss the issues that you raise in this moment for a number of reasons, including the fact that the establishment of the facts is really problematic. So even the OSCE mission was very careful in clarifying in very clear terms what is the law, but of course it was very careful in explaining that the establishment of the facts in this moment requires it's a very delicate issue, and don't want, of course, go into the details of the discussion concerning the recent Amnesty report concerning the alleged violation of IHL by Ukraine. But apart from the way Amnesty International conceived the law, apart from any political consideration concerning the way they then made the report public, it remains that there is an issue concerning the establishment of the facts and the correct application of the law. What I would like to stress in any case is related to the issue of precautions in attack. That is a very interesting topic for further analysis in my view, particularly with respect to the issue of passive precautions that indeed shows somehow not only well, it shows, and this is something that I would like to stress, it shows a possible further role of local governments in implementing the obligation of passive precautions. Article 58 of Additional Protocol 1 is pretty clear. The parties to the conflict shall, to the maximum extent feasible, and of course this is the most problematic issue from the viewpoint of the implementation, endeavor to remove the civilian population, individual civilians and civilian objects under their control from the vicinity of military objectives. Avoid locating military objectives within or near densely populated areas. Take the other necessary precautions to protect the civilian populations, individual civilian objects under their control against the dangers resulting from military operations. Now, the correct implementation of these provisions in consideration of the criterion of feasibility is, of course, a very challenging issue. And I think that goes precisely towards the kind of reflections and the considerations that you were making. So at least from my viewpoint, the issue of passive precaution in situation of urban warfare is still a topic for further analysis and research for experts in the field of international humanitarian law. I think it's time to conclude, and I take the minute that I mentioned before to thank you all for coming, for presenting and commenting, and in this very fruitful discussion we had this morning. The impression I have is that cities sometimes become symbol for us as for the meaning that I played as for the evolution of international humanitarian law. This summer I was in Bihać in Bosnia, and I couldn't but observe that a city that is now at the center of the so-called Balkan route, and it poses a lot of questions with respect to the implementation of human rights law and refugee law, including the principle of non-refoulement, was one of the safe areas proclaimed by the UN Security Council during the war in the Balkans, and one of the cities that was indeed under siege during that terrible war. So in some cases you have in a single city, even a tiny one like Bihać in the north of Bosnia, you have different layers of situations in which international law becomes relevant in our discussion. And I think also the chapters that discuss indeed the symbolic value or the role of the cities in the evolutions of international law, being the seat of certain international tribunals, or being the headquarters of international organizations, or where multilateral negotiation was held, actually help us to even enlarge our understanding of the role and the relevance of cities under international law. Now I give the floor to Helmut Helmut Aust for its concluding remarks. Helmut, you have the floor.
Yes, thank you very much, Mirko, for giving me the floor, but also for co-organizing this wonderful meeting here with Pepe together. I think I can say that personally, but I think also speaking for many others, it was a very rich morning, which has really generated a lot of food for thought, and the task to deliver concluding observations is always difficult, and you can never pick up all the themes which have been mentioned, but I will try to together a couple of points which have been made more or less explicitly during the day. So I would like to focus on 3 points, and hopefully also not more than 10 minutes, as we're lagging behind a bit with the schedule, so I don't want to spend too much time. And these 3 points concern, first of all, the changing geopolitical context that we're probably finding ourselves in, which was something which was mentioned here and there during the morning. The second point, the relationship between the 2 projects which have brought us together, so the research handbook and the Italian yearbook, and which implications we can draw from the relationship between these 2 projects. And then maybe briefly, thirdly, and this is a bit more scattered and random, some blind spots of our research agendas and possible further avenues which we could pursue. So let's move to the first point, the changing geopolitical context. And the reason for this point, I think, is obvious. It has been mentioned a couple of times, Russia's war of aggression against Ukraine, which did not really start this year, but escalate this year very severely. And in a way, I think many of us are constantly asking, to what extent is this changing our perspective on international law? And I think we have to ask ourselves the same question with respect to the role of cities. And maybe one reason to ask this question specifically is that when one looks back at the emergence of cities as internationally relevant actors, one can see that in a way, this is a story which has begun in the 1990s at a certain moment after the end of the Cold War, when there was a lot of optimism in the development of new international institutions and a reconsideration of the role of the state. And this is an issue that Janne and I are currently also grappling with another publication that we prepare for the Cambridge Handbook on the History of International Law, where we have been asked to write on this topic. Now, in a way, it's obvious to ask what does this changing geopolitical context mean for our topic. On the other hand, it is a fairly general remark. And in a way, I think it becomes more concrete if we go back to, I think, at least our ambition with the handbook to show that international law is in a way transformed by the emergence of cities and other subnational actors. And the question then is, can we still make this claim if we see that other actors like the state are making a massive comeback, so to speak? And does this new situation change our priorities in a way which makes it kind of a bit frivolous to continue to look at this new topic and claim, well, international law is now transformed because of this emergence of cities? I think there would be different possible trajectories. One trajectory would be to say, well, this phase is now over and we are back in a phase in which the state is really at the center of international law, and this will also lead to a consolidation around kind of a harder core of international law, and many of these new developments will be done away with. Another trajectory would be, well, what cities do is so connected to technical forms of cooperation that they are largely unaffected by these changing geopolitical trends. And then somewhat unimaginatively, maybe there's a third option, a middle ground, which says, well, we cannot yet answer this so clearly. And maybe what we could observe is that different parts of international law will also react differently to this development. And Ricardo mentioned, for instance, in his presentation, how successful this local turn has been in certain parts of international environmental law. And then at least I would hope, and I would also hope that this is a realistic assessment, that not all of these successes will be rolled back, so to speak, and that even if international law may not be transformed as a whole, as some of us may have wished, at least certain islands of international law will endure in this regard. And in terms of concrete steps to follow here, I think what will be particularly interesting to watch is a process which I presume will start soon to look beyond the SDGs. We are still very much concerned with the SDGs as the blueprints for global sustainable development. They were adopted in 2015, the Agenda 2030, but we're almost halfway through the commitment phase of the SDGs. And there will need to be some kind of follow-up process which comes after the SDGs. And when we see how cities have gained recognition with SDG 11 in this form, it will be an important test how this at least partial ascent of cities to the international level will weather this geopolitical storm, and how a follow-up document, whatever legal nature and form it will take, will play out in this regard. My second point, and I also promise to become briefer. I will follow Janne's example. The second point is briefer than the first one, hopefully. The second point, the two projects and their relationships. I think that was mentioned in various points during the day, that the Italian yearbook and the research handbook came kind of from different starting points to the topic of cities and international law. And in a way, they also doesn't do justice to all the contributions in the two books, but in a way, they also set forth two visions of international law. One is more classic in a way and focuses on more traditional notions of subjectivity and the sources of international law. And the other one is trying to transcend these categories or question them, at least to a certain extent. And what we tried to do with the handbook is, and we described that in the introduction, is that we also wanted to move beyond kind of a mapping exercise where we just trace what's going on in the world of global governance here and there, and that cities matter and that this is happening, but that we wanted also to start a conversation on how fundamental concepts of international law are affected by the rise of cities and their networks towards becoming internationally relevant actors. And the interesting question would now be how we can build further bridges between these two approaches. And I wanted to convey this message to Pepe, to Professor Nesi, so someone else now has to do that. In the most recent ILC report, there's a highly interesting suggestion by the French colleague Matthias Forteau for an inclusion of a new topic into the work of the ILC. And this suggestion is that the ILC should focus on non-binding international agreements as a topic. And Professor Forteau does not have in mind that this should be a project on cities and international law, but I think it's a further step to acknowledge the informalization that is taking place in international law. And if a body as illustrious and sometimes conservative as the ILC would be looking into these non-binding agreements, I think there would also be more openings for bringing in what cities and other more informal actors do on the international level. So maybe in this context, there's room for building bridges between the two approaches. Lastly, further, or maybe some blind spots of the agenda, not really blind spots because they've been mentioned today here, but I kept thinking about kind of potential further avenues of research. And the first point which came to my mind follows from the observations that Professor Francioni also made in his contribution to the Italian yearbook, and this question of the urban and the rural. Janne, you also mentioned that in your introduction, who is actually represented if we elevate certain actors to the international level. And I think a lot has been said about the various points in this regard. What could be an interesting research avenue would be to study on a more systematic and comparative level how the different forms of subnational actors are recognized by the international system. And I say that with some hesitation because in my own work, I was always super careful not to cross into the territory of federalism and international law, because this creates all these special issues related to federalism. But maybe it is time to actually consider in a more integrated way how different forms of subnational actors can engage with international law. And this would relate to federalist systems. It could relate to regions. Speaking here in Trento, I think it's very obvious, it came up in our conversations, how regions also mattered here and how they also connect to supranational levels. It can pertain to cities, but it can also pertain to what has been mentioned a couple of times today. So this Declaration on the Rights of Peasants and Indigenous Peoples. And I think in all these instances, one runs into a similar problem, that all these levels of governance, all these collectivities are addressed by international law. And then the big question is, how can they feed back into the processes of international law? And it occurred to me today that this might be something fruitful to pursue further. And then last point in this regard, and this combines also observations from Ricardo and Janne to a certain extent. Ricardo, you spoke about the voluntary local review, and Janne, you talked about, or you brought up this point: do cities actually deliver? How can we also hold them to their promises? And I think what would be fascinating in terms of international law scholarship is to bring in people working with empirical methods here, and maybe take a close look at these 100 voluntary local reviews and actually compare what this means, and thereby make use of empirical legal studies, approaches, bring that to the city level research. I think there is already a lot going on in the field of political science, but then political scientists working empirically ask different questions than lawyers working empirically are typically asking. So this might also be something, also maybe a valuable PhD project of someone either here, maybe not, or virtually is looking for PhD topics. So I think I will stop here, also having talked for 10 minutes by now. Thank you again to Mirko and Pepper and everyone else. That was an extremely inspiring morning, and I also really enjoyed it and learned a lot, and I hope that we will continue these discussions between the two groups of authors and with everyone else. Thank you very much.
Thank you very much, Helmut. Very last thing is just to thank also those who followed this event online. Thank you for your patience, for your attention. And we definitely look forward to continuing our discussion on other occasions. So thank you very much. Have a nice day, and see you hopefully soon in presence again.